people who are middle-aged and who have, completed manufacturing and they're successful would only go in for exports. But today it's not true. Today, a lot of youngsters we find, walking into our offices, and many of them are students. There are faculty members also, they say that they have resigned from a particular college because they find that the export sector is very lucrative for ways more than one. And that's how they mean business, and youngsters and old alike. There's a lot of space and room out here. So let me just quickly share a very brief presentation that I would like to run through, which represents the organizational mandate. So here we are. So in fact, before even giving you a slice of the feats that I say, not sure how many of you are aware that we are one of the very few export promotion centers in the country. Meaning exports do happen everywhere and you do have verticals, but then, exclusively a department, a unit as such under the government aegis promoting exports, Karnataka is one of those very few states. And some of the achievements as I have put out there are very, very significant and means a lot for a state like Karnataka, which is trying to inch fast on the growth trajectory, on the economic parameters. So we were recently ranked as achiever status in this LEADS survey, which is like an annual survey every year, which assesses on the logistics parameters of any state. So under the coastal states category, we were ranked the achiever status, and for all these that I have listed out there, good infrastructure, exemplary network and transparent ecosystem, and also in the overall operating and regulatory environment, and of course the quality of warehousing services. Not sure how many of you are aware that the Niti Aayog conducts every year, just like how we have the LEADS ranking, we have the Innovation Index ranking. And you'll be very happy and proud to know that Karnataka has been ranked consistently as a major innovative state. A major innovative state in the country. And in the recent one, we've been ranked number 3. This number 3 is for the export promotion part. And when it comes to innovation, we are the leaders there in the major innovative states category. And number 3, as I have put out there in the recent export performance index. Now, this is also very significant because this is up from the 9th position that we had. And of course, we are waiting for the latest EPI index ranking as well. Policy first, I'm sure you've heard enough from me as to how, we pride ourselves as a state which has given several firsts to this nation in several spheres of the economy. We continue to do that. And that's what is, very interesting about Karnataka. You name it and we are there. Like way back in time, as I always have said, when, whether the biotech space or the IT space was in its nascent stages in the country, Karnataka was the first state to come up with an exclusive policy for the sector. And we didn't stop there. We went about in good steam. We spoke about a retail trade policy. We spoke about sector-specific policies for the agri sector, for the energy sector, and even for this non-resident Kannadigas, there's a policy there. So you name it, and we are there. And of course, the Karnataka startup policy as well is one of its kind in the country. The electric vehicle policy also was among the recent pack. And of course, the geographical indications policy announced in 2019 under the IPR spectrum, I would rate this as one of the very key policies of the state. Also because Karnataka pioneered it in the country. We are the first of its kind policy which no state yet has come out with in the intellectual property space, exclusively for the artisans. And you all know that we are the leader across various verticals. Again, just name it. Silk Hub, we are the coffee hub. And in fact, we are also the geographical indication tagged coffee hub as well of the country. Then precision engineering number 1 there. Very strong presence in aerospace, automobiles, biotech, so many more. In fact, in the agri sector, we are called as the Museum of Crops. The reason is for the variety of agricultural products. So if you look at Karnataka as a whole, the entire basket, you will realize that as an entrepreneur, you can add so much value. And startups, need I say more? So that's the order of the day now. We are also the cradle of the Indian banking system, as you all know, because several banks have originated from the state. So I was talking to you about the charter of the Visvesvaraya Trade Promotion Center for the promotion of international trade. So we facilitate, we handhold all the potential, the budding exporters, those who are already there, who are already into manufacturing and now want to foray into exports. There's room for everyone. Now, all of you know, my dear friends, that exports basically is a central government subject. But both the center and the state provide you with a lot of incentives and schemes. And that's also one of the reasons why the sector is very, very lucrative. So what VTPC does is we come out with an industrial policy every 5 years. So right now the 2020 to 25 policy is on. My photo. And there we implement the export promotion chapter. Is what we implement. Can the audience be muted, please? I don't think it will come. Organizers,
yes, ma'am. Yes.
Video call if you open. Not video. This one.
Yes. So out of all these bullets that I've put out representing the charter and the mandate for VTPC, one of the very interesting ones I would say, and I would urge all of you to take a look at this, because if not you, it could be a friend of yours, it could be a sibling, it could be someone in your network of fraternity who may be interested. Now, if there is someone who wants to get into exports sooner or later, we would advise that they take this 6 days incisive training program that we offer called Export Management Training Program. And it's like a capsule basically of all the, who's who and all the nuances that go into setting up of getting into exports and setting up the export space for yourself. So starting from what is the significance of an IE code, that is import exporter code, which is a starting point. And then the parent of it all, the DGFT, the Director General of Foreign Trade, what is their role? What is the role of customs? What are the customs procedures? What is the documentation process all about? Because please understand, in exports, there are n number of contracts. It could be an insurance contract, it could be a forex related, it could be a marine, shipping, several of them. So what are the exact specific documentation processes in the whole scenario is what we provide insights. Also, how do you get into the pricing, costing aspect, and what are the institutional frameworks in place, and which are the key councils or agencies in the international trade arena that you should be engaging with and should understand, and how do you understand the space in terms of the sectors, the potential. So all of this capsuled into 6 days, I would say 5 days, because last but one day we take you all on a live visit to either the airport or the container depot to get a feel, hands-on feel of as to how exports happen in the real-time basis. And this is one program, my dear friends, which just happens word of mouth once in 2 months. And we really do not advertise it much, but then people who have attended, they vouch for it as to how it is so professionally conducted, because the right experts, the right authorities in the space, including success studies of successful exporters, who tell you that, hey, we thought export is a rocket science, but then with a little bit of logic, common sense, and a couple of important parameters, you all can make it there. Then we also implement the MDA, that is a Market Development Assistance Scheme under the Industrial Policy Export Promotion chapter. So here, wherever folks want to go abroad on, let's say, a foreign delegation, or they want to visit a specific country, want to scout businesses, this particular scheme will be of great help. So you go there, directly interact with your buyers, and find your markets and come home rich with a booty. So that's the Market Development Assistance Scheme for you. And we also facilitate the SEZs. There's a policy as well there. We also implement what is called as TIES, ties. It's something to do with infrastructure support for exports. And you'll be happy to know that even academic institutes have availed the scheme in the past. And this particular scheme erstwhile was known as ASIDE, ASIDE, and it's all the same now. It's renamed right now. And the academic institutes in town also, with a mandate for exports, have availed the scheme. Then services sector. We have been hearing so much about the $1 trillion economy vision, $5 trillion service economy. So in that, the services sector, and especially the champion services, are going to play a very, very important role. So Government of India some time back had identified some 24 sectors, service sectors, which they said are going to play an important role. And Karnataka shortlisted 6 service sectors in the first leg. And we identified them for formulation of action plans with the respective departments, which provides a roadmap, for suitable interventions. So of these sectors, you'll be happy to know that one of the important service sectors is the education space. So we've identified education among the services sector as great potential for the economy. Then we've identified media and entertainment. We've identified logistics and transport, which is so very important, remittances and immigration, health and wellness, and also construction and allied engineering services. So these are also some triggers and food for thought for all of you, my dear young budding entrepreneurs, be it exporters or manufacturers. This is the order of the day. You can look at such sectors as well, which the state is talking about. So how do we reward and recognize the ingenuity of our exporters? So we have this particular awards called Annual Exporter Awards for Excellence, which is conducted under the aegis of the Honorable Chief Minister of Karnataka. And this is where the exporters get a platform to showcase their ingenuity and get, it's like giving them a leg up here. I've already told you that we implement the export chapter under the state's industrial policy, and the geographical indications in particular, as I said, is an exclusive one in the country. We're the first state to come out with an exclusive policy to protect the artisanal products. And BTPC is the nodal agency for the promotion of geographical indication tag products from Karnataka. And you've heard about the Atmanirbhar initiatives, like we were talking about vocal to local, local to global. And then we also have been talking about one district, one product scheme, then the developing districts as export hub. So these are different schemes which at the end of the day talk about how to promote sector-wise or particular product-wise exports. And of course, the charter, the intellectual property right initiatives that I represent here at this organization. I've just completed 10 here, and I have been sensitizing this space, across the stakeholder spectrum, be it the startup, be it industry, be it the NGOs. You give us any kind of audience, and we believe that everyone needs to be sensitized, including the office boy, including the homemakers. Everyone needs to be sensitized on intellectual property, and my good friend and esteemed speaker, Soumya Shri, will take you through this entire gamut. Coming to the major exports and imports of the state, because this will also generate some kind of an interest among some of you who may be in the future becoming budding exporters of the day. So these are some of the major exports, and as I'll put out a slide subsequently, you'll see as to how Karnataka ranks #1 in the export of software services, more than 40% share in the country. And these are the sectors where we are very strong. Aerospace, defense, precision engineering, I told you we are #1 there. Ready-made garments and silk, another good, very potential one. Coffee and processed cashew, rose onion, gherkins, medicinal plants, vegetable extracts, pharma, petroleum products, and agarbattis. There are many more sectors where there's a lot of potential, but these are where, we would say major exports happen. And of course, the imports as well, as you can see there. Now, coming to the power of ideas and innovation, today's topic about the intellectual property spectrum. Remember one thing, my dear friends, there's nothing like a very great, magnificent idea or a very small or trivial idea. An idea is an idea, and I'm sure you'll agree with me that there are n number of examples in world history. Those ideas which became inventions were just by chance. It's not that someone went about technically as a technical expert, putting, donning the innovation cap and saying, hey, I have come up with this product and that's ingenuity about me. No, wrong. There are many, many examples in history to prove that there were many products which happened by chance, and those people became very popular and went into the Hall of Fame. And when I talk about some of these pictures that I've put out, everyone knows, the world knows what we are talking about. You know about the Edison's bulb, we know about the radio, we associate names like Tesla and Tesla and Marconi and all. We also say that the Wright brothers gave the first flight, right? And then of course the telephone, way back in time, Graham Bell. Hats off and salutations to all the inventors. But there is something very interesting that I would like to connect with this slide. When I move towards the end of this slide, I'll come back to that. So just capture this particular slide in your memory. And ideas need not really be complex, as I was just saying, and I was talking about how things happen by chance. Post-it notes is one classic example. I'm sure many of you are aware of the story as to how the post-it note happened. It happened by chance. It was an accident. It was not meant to be. It was some other product that was being actually developed. But in the process, the particular, I would call him as an inventor at the end of the day, ended up with something which people thought in the company, hey, what do we do with this now? And then they realized this can become something very useful for the world. And that's how Post-it notes came up. Similarly, if you look up the World Wide Web for the story of the potato chips, something very interesting and amusing about that as to how a gentleman gets into a restaurant and orders for something, related to a potato, and he doesn't get any kind of a satisfaction with what the chef doles out. And then the chef thinks, let me now just think, put my ideation cap on, how to satisfy this very troublesome customer. And that is how the potato chips was born. And that's all history for all of us. Even the popsicles, the first ice candy, happened by chance. A little girl, 14-year-old, just put out one glass tumbler with a little bit of ice candy there, some liquid juice, and early morning she finds it's frozen, and that's how this candy concept began. And similarly, the invention of the matchstick and the safety pin. Where would have we been, especially we ladies, the women fraternity in particular, where would we have been without that safety pin? Appears like a very small thing after all, but then that's something that today we cannot do without, right? So my dear friends, remember, as startups or as any individual, as an inventor, when you're thinking about products, just think about some simple resolutions or problems to some complex problems that the world is facing. Come out with some simple solutions, and that itself is a great invention, and that would be the need of the hour. Now, some of these intellectual property tools, all of you have heard about it. The toolkit, Soumya will take you through the entire thing, but just to give you a certain point of a recall, that when you talk about patents, you're protecting your inventions. It could be a process or a product. And when we talk about trademarks, you're protecting your brand, the logos, and the entire gamut. Copyrights, very, very significant for academia, especially when you're writing papers, research papers, and a lot of this, when you're downloading stuff from the internet, the music and all of that, we need to check for the copyrights. We need to honor and recognize the work of the original author. Because it's very easy to copy stuff, download stuff which we have not done, where we don't have a copyright. But then just imagine, put yourself in the same shoes. Tomorrow it could be, today it was him, tomorrow it could be you, and then it could day after be your sibling or your offspring. It could happen to anyone. So let's not get into infringements. And even as a nation, I would say that we're so proud about our rich culture and heritage. We want to profess and do the right things. So let's be on the right track and honor others' creation. So let's respect others' intellectual property. And this is one important takeaway for all of us, right, as we go back home today after these slides. So respect others' creations. Just acknowledge it. There are ways of doing it in business. Industrial designs. So I may think, well, I'm not an engineer, I'm not a technical expert. So what are we talking about? How do I go and file a patent, which appears so very technical? Why not we think about some aesthetics part of one particular product? If you believe that, let's say, a remote or a chair, a pen, you've come up with some good aesthetics, only the overall part of it, right? Not the technical specification, the layout part of it. If you feel there's something very, very aesthetic about it, please go ahead, protect it as what is called as an industrial design, which is an intellectual property. And similarly, how do we reward the farmers and breeders of crops when they come up with, wonderful varieties? You have another tool there in intellectual property called plant varieties. So that's how you should leverage it. So you should know how to leverage the various IP tools and when. And when can you think about a blend of them? So these are things which you have to check out. Traditional knowledge. You know about the grandma recipes, you've heard about the case stories of neem, turmeric, basmati and all of that, which goes to prove that India being so rich in its cultural, in its cultural repository and all the traditional knowledge that we have documented, we should be aware of all these rights. And only when we are aware, we will not allow anybody to infringe it. I'm sorry. Similarly, the geographical indications, which is a community right, unlike patents and trademarks, it's GI is a community right. So tomorrow we cannot say that I own, let's say, Nanjangood Rasbale, or I own, Kurga orange. No, because it's a community right. All the artisans in the particular fraternity, in the community, in the region will benefit from this particular intellectual property tool. And similarly, trade secrets. So, well, you don't want to disclose anything to the world, so be it. So as long as you know how to protect it yourself, good enough. Some of the IP alerts, sorry, golden rules of the thumb. Now, tomorrow you may become a startup, you'll set up shop. So as I already told you, first learn to respect others' intellectual creation. And then there's something called a prior art search. I'll not go deep into it, but then this warrants a full-fledged subject. But just to let you know that anyone who's sorry, who's already having IP over some particular product or a tool or a particular part, we ought to go up to that particular creator or the inventor, and when we are setting up shop, we have to ensure that we do not infringe this person's intellectual property, or it could be a patent, it could be a trademark, any kind of an IP. We need to ensure that. And how do we do that? How do we know that? Well, I am going to set shop. How do I know that X, Y, Z already have an intellectual property right over a particular tool or a product? There are ways, and those are called prior art search mechanisms. The databases are there to tell you as to where you stand in terms of your technology or your invention that you have come up with. Where are we, right? So that prior art search will reveal to you where we stand, and depending on that, we needn't lose heart if it says that somebody already has, taken an IP on that. Let's not be unhappy about it. It's just that we needn't reinvent the wheel, and we will be able to take it on from there and see as to how you can better your innovation or invention and how you can take it forward. So various ways of going about it. And if somebody already has an IP over a particular tool, what you have to do is just go and take an IP license, get into a commercial contract. And ignorance is not bliss in IP, my dear friends, and Soumya will also tell you about it, as to how there are many, many companies in town which have been given the mandate only to check who's infringing what. And that's a very, very big business. In fact, in the lighter vein, I would always say, but on a serious note again, one of the booming careers in IP is the space of IP infringements. Because like everyone means business. I have created something, I have spent my time, my might, my monetary resources, everything, and here is someone XYZ who's trying to transgress. This is not done. So how do we protect? So we need to protect our turf. We cannot afford to be ignorant in the world of intellectual property. And the classic example is the examples of turmeric neem, which all of us have heard. Just for the sake of quick recap, to let you know as to how, because India was aware of her rights, nobody could make mess when it came to the turmeric controversy. And the story goes thus, for people who may not be aware of the full story, that there were two Indians in the US who had patented a drug where turmeric was involved. And the US Patent Office had granted this patent. But India was aware that turmeric is our rich TK. I was just mentioning to you about traditional knowledge. It is India's documented traditional knowledge, and it's our rich repository, which represents and mirrors our culture as well since ages. So how is it that these two Indians in the US got the patent by the USPTO? So what did India do? Because we were aware of our rights, CSIR on behalf of the country fought this case. And then we were told to produce evidence that it indeed belongs to us. We were very happy to do that because we had all the repository with us, the documentation to prove that turmeric and neem belongs to India. And this is considered as landmark cases in the world history of intellectual property. So India said we mean business, and we also have been the founder members of the WTO, the TRIPS. We have signed the trade-related intellectual property rights, and we adhere to the compliances. We ensure that nobody unnecessarily infringes our turf, be it any country, and we are going to protect the rights of our citizens. So it is the duty of each one of us, my dear friends, and all the youngsters of the day today, to ensure that we be aware of the IP rights and also cascade this information to the entire fraternity, saying that we better know that ignorance is not bliss and we know what are our IP rights. So I was talking to you that I told you that please capture that particular slide in your mind, right? Where we had the radio, the telephone. So I just asked you, what is so common between these inventions? So one answer would be those are all the popular inventors of the day, be it Graham Bell, Edison, be it the Teslas, the Marconis, be it the Graham Bell, all of them, whoever, and even Michael Jackson. That famous shoe that he patented, he has a patent for that. The typical angle in which he slides, he used to swing, that had a patent, right? But all these products, my dear friends, in all these cases, these particular inventors were not the first ones actually to come up with that idea. If it was Graham Bell or Edison, with all due respects, they were not the first ones. However, they were crowned as the inventors. The reason is that they followed the rules of the game. It doesn't matter in IP as to who comes up with the idea or invention first. What matters is the right time of filing your idea, converting your idea into a product or a process or other forms, other avatars of IP, and filing it at the right time. And this is precisely what all these inventors, all the popular ones, what I just put out here, they had done. While there were a lot of people who had worked behind the scenes and worked much earlier than them, they did a lot of work, but these were the inventors who went into the Hall of Fame because they went at the right time and filed the invention. So that's the message for all of us here, that please file and protect. Do not first publish, right? First file it. If you feel it's worthy of any kind of a intellectual property, I would not say patent, because all of us, tend to get mixed up with IP, meaning synonymous only with patents. It's not. You can look at the basket of IP tools. So if you want to, protect yourself, please first file it. Do not publish it. Like in academia, this happens often, that we come up with research papers, and then, as a culture also, we love sharing, and we publish it, or we expose our inventions to the world. Let's not do it until we file the particular intellectual property. And these are the last slides. Just take memories of these slides. I would not talk much here, although this is my area of passion. These are the geographical indication tag products, where Karnataka is one of the leaders in the country. We are the GI coffee hub of the country, with 5 GI coffees emanating from the state. And of course, we have added 2 new GIs in the crop segment now: Curry Ishad mango from the Ankola region and Indi lime from Bijapur region. We also have handicraft, 16 of them. I'm sure you've heard about all these names, or maybe at least a lot of them. Saris, Ilkal saris, Udupi saris, Mysore silk, and the crops as well. You have heard about Kurga orange, Apimidi mango, Bangalore blue grapes, Sirsi supari, Mysore beetle leaf, the various jasmine varieties, and the Kinhar toys, Chanpatna toys. These are all artisanal products of the state. We have an exclusive policy to protect them. And we're trying to see as to how we can give a platform to the artisans of these products to take it to the world. And I'm sure the budding startups and all other youngsters of the day will take a slice of these 2 slides in particular home and think as to how all of us can add value to this very, very interesting intellectual property tool, which is called as the sleeping beauty of intellectual property rights. Thank you so much for your time on that note, and I hand the floor to the next session speaker. Thank you, my dear friends.
Thank you, ma'am.
Thank you.
Ma'am, for your valuable time and valuable speech. Now I would like to introduce and welcome Srimati Daumishri, Associate Partner and Head at Alticid Global Bangalore. Daumishri is an Associate Partner and heads Alticid Global Bangalore branch. She is a trademark attorney and an advocate with 15 years of experience in the field of intellectual property rights. She brings her expertise to the table by advising clients in managing their intellectual properties, rights, and contracts. Her core areas of work include search, watch, billing, prosecution, and registration of trademarks, design, and copyrights and IP portfolio management. She has closely worked with many clients and has meticulously advised them in managing their IP portfolios efficiently. She has been a speaker at various intellectual property rights training sessions. She has also published an article, Micro, Small, Medium Enterprises and Intellectual Property Rights in Monthly Magazine of Kastia, Education and Qualifications. Soumyashri obtained a degree in law from Bangalore University in the year 2007 and has also acquired a master's in law qualification from Kuvempu University with a specialization in business laws. She enrolled in Karnataka State Bar Council in 2008. She also holds a postgraduate diploma in intellectual property rights from ASCL affiliated with GLC. I would like to request ma'am to talk on the on leveraging intellectual property tools for startups. It's over to you.
Thank you, Dr. Indrika, and thanks everyone for giving me an opportunity to talk today and help you understand the simplicity along with its complex legal jargon called as intellectual property rights. 1 minute, I'll share the. Am I audible to you all?
Yes, ma'am.
All right. Like we all know, or you just take any case study of any company, which a small MSME or a big corporate companies, every company starts with a small, it has its background to a small single idea. Everybody traces their success to a single idea. It could be anyone. You take Apple to a small company where other day I was talking to one of the French companies, and she is into AI in a fashion technology, right? So when I met her, actually I got to know about her through one of the webinars, and when I met her, she said, Soumya, Bangalore is coming on the global scenario where it is put in front, because even AI, Bangalore is doing well because we have a very good infrastructure for the intellectual property, and recently they purchased a small idea of a startup of 4 people for 4 crores, the AI patent, which was patented. Okay, so always remember, any idea, like Prabhavati ma'am said, small, big, natal stages, always see what is your takeaway. If you can create a business out of it, if yes, then initiate your intellectual property protection. Initial, 1 minute here. Okay, see, protecting your intellectual property rights is not something new to us. The humankind has known intellectual property rights and its protection forever, for many centuries now. The first as such intellectual property protection, which was granted way back then, is dating back to 5 BCE, wherein the chefs were given the protection to a recipe of baking a bread for 1 full year. It is a monopoly right, and they could make their living out of it. It is, our intellectual property protection is as old as that. Before 1985, we always had this concept of, first we will do some research, then we will put it into manufacturing. For manufacturing, we need labor, we need land, we need machineries. We purchase all that, and whatever comes out of it, we put it into marketing and sales, and then we sell our products. Whatever revenue we receive out of it, the product's revenue goes back to R&D. The economy in the Industrial Revolution was limited to that. Labor, land, and some amount of corporate structuring. But things changed. There came globalization. The globalization came into marketing and the manufacturing. More companies means more competition. If there is more competition, every company will have a lower margins. When there is lower margins, you have to step up your R&D. You have to be ahead of other products and services in the market. This is where the company started shifting from manufacturing unit into R&D units so that they can get a competitive edge. Here manufacturing started becoming a commodity. Apple Inc. concentrates on R&D in US, but manufacturing for them, it is a commodity. They will push it off to a low cost and cost effective countries like China, India, and other low wage countries. This is where IPR started becoming a strategic weapon in the competition. Now, from industrial economy, we have shifted to the knowledge driven economy. What happens in the knowledge driven economy? Your knowledge is your asset. It could be, as like I said, 4 people startup can earn with one single patent, they can earn 4 crores. So how did they do it? They saw what is the problem. This is basically a AI driven technology in the fashion industry. They found out the problem, they figured out the solution with their R&D. Once the idea was out, they patented it and now they licensed it. Here you license it and you earn your revenues. What do you do with those revenues? Like the slide says, you put it back to the R&D. So this is a cycle of any company. You ask, ma'am, what should startup do with it? All the Apple Inc. or it could be Sony, to anybody, we all believe of the fact that intellectual property rights is always for big sharks. Okay. Very recently, because of the incubation centers and because academia is interacting with the industrial sectors, there is a certain amount of drive to protect our intellectual property rights even in the startup. However, it is at a very natal stage because people, there are a lot of things with the IPR. Some people say, why to protect intellectual property rights? First of all, it is very costly. Second thing, what will I earn with it? In intellectual property rights, when you're protecting it, always remember one thing. There is nothing how early you begin protecting. It is always like how late you are, because by the time you realize, somebody would have swept that idea from you and you will be at loss. How does this intellectual property rights protection help a startup? There is a funny thing. For any startup, initial capital or any business, initial capital is very important. The first thing, where do we get this initial capital from? The 3F, family, friends, and fools. But these 3 things we always exhaust, right? After that, what? This is where your intellectual property rights, your asset valuation will come into picture. If you have your IP protected, if you have your strategies, then you can use your IP for various ways of licensing. You can assign them, you can sell it off, or you can enter into JVs for productions, or you can also obtain, you can keep it as a security for a loan. The best example is Kingfisher. The Kingfisher logo was given as a security for 3,000 crores. 3,600 crores is its IP valuation. Like I said, how do you monetize your intellectual property? First of all, your idea is yours. Bring out the products, bring out your services. From lab to the market, there will be something new in your product which is different, which is standing out from others' ideas, where it could be in terms of cost, it could be in some terms of quality, it could be in terms of the society satisfaction. Bring those, monetize it. If not, if you're not able to do it, license it or you franchise it, or you can sell it off. Next thing, as Prabhavati ma'am was saying, litigation. These days, the companies are engaging people to monitor their IP, to see who is infringing, because just protecting something and putting it in the lockers, these days, I don't know how many women here, but if you agree or not, we all buy Akshaya Tritiya, a lot of gold, and then what do? We are scared to wear it. And what we do? We put it back into the lockers. Right? IP is not like that. You have to make it work. How do you make it work? Litigation is one such thing. You have to enforce your rights. If you don't enforce, it is equal to gold in the treasure. It will not work for you. There is a beautiful case. I have forgotten this person's name. He is in US. He has filed around, he's in his 60s now. He lives in US. He has around 10 prime patents, software patents. he never, the only way he enforces this particular inventions or the patent of his is by suing big companies. Every time he has his inventions protected because these are the core ideas for many phones to work. So always he builds around the same invention, he develops it, he patents it, he sits. He sits and watches for somebody to come and adopt that particular idea. The moment it is adopted, he will file a case. Apple has already been sued by him, and of course they don't want to go against him because that is a core idea. So what they do, they compensate. They don't want to go beyond it. They compensate, they shed it. He is happy, enough, no problem. One individual, I get a few crores of money, I'm happy. So this is another way of monetizing your intellectual property rights. Let us take the case study of Apple Inc. I took Apple here because all of us are very aware of it and it catches our ears. Steve Jobs has got had the best attitude, wherein he said, if any employee even dreams of a certain idea, just apply for the patent. We will see it later. Why? Because if you don't build on that particular patent, no problem. At least it will act as a defensive tool, meaning litigations. Apple has got around 56,000 odd patents across the world. As of today, this is the latest update we have. And yesterday also, I think somewhere in Europe, one of their patents were granted. So each day, somewhere in the world, Apple gets one patent granted. They are that protective about their invention. Every single aspect, you take it and they file a patent for it. Because the more, especially products like this, which is today new, tomorrow is obsolete, it is old, technology is that fast. In those circumstances, you have to have your patent, because every day there is no breakthrough ideas which come. It is always innovations. One step ahead, they will still file a patent, because for that company, it is their bread and butter. As of today, their current portfolio is 1,000 odd registered patents, 360 plus unregistered, but they have filed trademarks. 70,000 plus utility and design patents is what they have. And Apple spends in the past March 2022, they have $6.387 billion invested in R&D. That is their core thing. They don't trouble themselves with manufacturing. Like I said, it is a knowledge-driven economy. See, now by using your intellectual property rights, this is how you can become from a technology rich company to a very rich technology company by using your IP as your key strategy in earning for you. What is intellectual property rights? Intellectual property rights, as the name itself suggests, it is an intangible tool, meaning something which you cannot feel or touch. It is a tool which will help you protect the ideas which is created by yourself. There are a lot of IP tools, as it mentions in the slide. There is patents, trademarks, copyrights, design, trade secret, GI as ma'am said, protection of plant variety and layout designing. We will concentrate today on prime areas of patents, trademarks, copyright, design and trade secret. Patents basically will protect the invention or innovation that you have towards a technology. It could be a process or a product patent. Patent is basically given for, it could be a software technology, it could be any sort of an industrial technology. It should be something which is of use in the industries. The logic of why patent is granted for a certain period. Patent gives you a monopoly of 20 years for that particular idea. In exchange, the government says, you disclose every single aspect of your invention to us, put it into the public. I will assure you that nobody will copy it for the next 20 years and you will own the monopoly of those monopoly rights of that particular invention. Why was this arrangement made is, I'll give an example of China. Way back when China discovered silk, or sorry, they invented silk and paper, they kept it so close that it was further, it never came into further use, right? Until we broke in and we understood the manufacturing of it. So if the humanity has to grow, there has to be inventions and innovations. This is where patents come into picture. We develop on the existing inventions and then we bring new products into the market, which is more convenient for the good of the society. There are two kinds of patents: process, product. I will take a simple example to break this down. Let us take the pharma product, okay, a tablet. The tablet is the product itself. The process, the way you put the chemicals, how you bake it into a small tablet is the process. Of the process and the product patent, product is a very strong protection which is given, and it is very difficult to get the product patent. Meaning, if you get the IP rights or the patent rights over the tablet itself, no matter what kind of different processes you bring in, you cannot get the rights over the product because that product belongs to you. In process, it is not like that. Today, A plus B is equal to C. Tomorrow, somebody else says D plus F is also equal to C. Both are processes. Each one will get the process patent in a different way. So what are the requisites for patent registration? One thing let us remember, for intellectual property protection, very important is your idea should be new. It should be novel. You should not copy others. This is a primary requirement of any intellectual property protection. You are granted protection only if you are new. Here, if an invention is novel meaning it is new, it should be non-obvious, meaning if 2 plus 2 is 4, everybody knows it. 2 plus 1 plus 1 is also equal to 4. It is a very obvious thing. If tomorrow you say 2 plus 1 plus 1 is equal to 5, that is a non-obvious. You will have to prove it. Okay. It should be novel, non-obvious, and it should be of utility. You can't just like that go for a patent and which is of no use. If it is of no use to the public, then the patent will not be granted. It should have some industrial applicability to it. What is not patented? It is a long list. I will break it for you in a very simple way. Something which is contrary to natural laws. E is equal to mc square is proven. We don't want to touch that part, because if that part is touched, many other things will be again undone. So if you tomorrow file an application that no, E is not equal to MC square, it is MC4, patent registration can't be done, the patent will be rejected for you. And it should not be a mere discovery or a mixture. You mix 4 products. I had a client, a small boy who had come to me, he mixed barks of 4 trees and he said, ma'am, I have got a new product, register. No, it is not possible. You're just mixing it. They don't give. Any agricultural methods is not granted because food is very important and monopoly is not granted to the method. I'm not talking about the plant varieties or the seed varieties here. It is the way of agriculture. The mathematical and the business programs, combinations, algorithms are not granted. Any mental act is not granted. You do, if you learn magic tricks, it's a magic trick. We do not grant patent registration, is what the government says. And of course, like ma'am very beautifully said, traditional knowledge can't be patented. Ma'am, Pravati ma'am was talking about the safety pins. Just like that, in my case study, I have taken a very simple patent where I am not sure how many people would have seen, if your fathers or grandfathers would be using a razor. It is a simple idea wherein the blade, a thin slice of blade, was sandwiched between 2 pieces of metal and held together with a screw. This was patented by King C. Gillette in 1904. You won't believe, even after 100 years, this particular Gillette company is been thriving with the patents and has actually monopolized the market pretty much, because all of us have seen our families using Gillette. Let us take the case law of Mac 3 razor case, wherein Gillette, like I said, Gillette has a very, like Apple, has this concept of patent every design and engineering feature. What they did, they applied for a patent for a razor with 3 blades and its positioning, the angle at which it positioned. Gillette has always been the monopoly in the market. It is a market leader. The same way it is in competition with Schick. Schick also came with another product of the same thing called as Quattro. Instead of 3 blades, what Schick did, they put 4 blades and they said ours is better. But Gillette, very beautifully, the patent attorneys had filed the patent for them, wherein it had said they had filed the invention for a razor blade with 3 or more blades. So no matter how many more blades you put, the patent of Gillette was still infringed and they had to pay a certain infringement cost to the Gillette. So the simple razor blade we all hold in our hands without thinking much has got 11,800 patents worldwide. For every nook and corner of that small blade has been patented and protected. So if tomorrow any of you want to copy, please be aware of it. And very specifically, I'll come down again, but since this is a point, always remember any ideas, any novelty, especially patents, because a patent is a money-making intellectual property. It is a very strong IP. Over the years, it has been proved that the technology is always worth more than other IP values. So if any of you have an idea, please ensure to invest. I do not say spend. Please invest on the FTOs. Please invest on the prior art searches. It is absolutely important because for you, you might feel it is something new to you, but you don't know. It would be, when I was talking to a friend of psychology, she was saying, we actually never forget things. It is somewhere at the back of our minds. So we tend to analyze that it is something new. We may not know, we could be infringing somebody else's patent. So please be sure that you always conduct FTO, and that is the freedom to operate. Freedom to operate is nothing but somebody else has got a patent in US, but you're free to operate or use it in India, because patent or all the IP properties are basically protected, are the rights granted by those particular nations. Except for copyright, you have to file individual applications in your market that you are playing. Let's go to trademarks. Trademark compared to patent is more simpler. However, it is something these days, because of the competition, it is given a lot of weightage. Trademark means it can be anything, just a word, a name, a symbol, a smell. It could be a kind of a sound, anything, or also a package. If it is something which helps you identify yourself to that particular product, meaning that name should identify to the source, then it is a trademark. First thing you would have to do whenever you are having a startup idea, everybody want to be identified to their companies. So always have a unique name for your product, because tomorrow that will become your identity. What are the requisites for trademark registration? Only one thing which is very important is that you should not be copying others, and it should be something which uniquely distinguishes your goods and services from others, and it will source, that particular name should source back to your services or goods that you're providing, which in terms of law is also correct. Not just that, as you grow, if you have a very generic name which is very similar to others, your competition is pretty much taken by somebody else, because you cannot prove that, you cannot tell the society in this competitive market that, hey, look, that product belongs to me, unless and until you have a unique name to protect for yourself. So what is not something which can be given a trademark registration is descriptive, meaning I can't sell my phone with the same name as phone. It can't be trademark. It is descriptive. It is describing my nature of services or my goods. It can't be identical. I can't sell Apple on my phone. Apple, it's a different thing. Apple these days, they are so strong on the IP protection. Any mark which has a pod in it, POD, they file. First thing is they'll send a cease and desist notice, and they'll start opposing the registration of the mark. They are that precise. They do not slow down. They want to protect the word pod for themselves. Okay, so ensure that your mark is not identical or similar to others. They don't give trademark registrations for geographical names or any individual's name, like my name Soumya. It can't be granted registration. Yes, there are a few people like Shah Rukh Khan, Sachin Tendulkar. They can, because they have identified themselves something above the normal social society. Let us take the case study of Red Bull. All of us know Red Bull. It is even to this day prime leaders in energy drinks. And Red Bull spends humongously in terms of advertisement. They, as of last year, they had spent around 338.7 million euros on advertising that particular Red Bull. They have trademarked pretty much everything, the blue, the red, the two bisons, and they also have the sun. Everything is individually protected, and they have they're very particular about protecting the Red Bull. And Red Bull has got its trademark registered in 205 jurisdictions, meaning to say, like I said, if you want trademark registration, patent, designs, they are all something which a nation grants you. So if you want to do your business in India, you will have to take registration in that particular country, USA, EU. All of that way, 205 jurisdictions have granted protection to Red Bull. With this, you will understand how important and a serious business it is to protect your trademark. Copyright. Copyright is on a very simple terms. It will protect your creative ideas. It could be your book, it could be some sort of a drama, it could be a music that you create, it could be any sort of a sound recordings, as in the sound recordings of the songs, and any sort of artistic work. It could be sculptures. All of these are protected under copyright. In copyright, there is something called as a Berne Convention. Don't worry about that word. It is basically an agreement where 160 countries have come forward, signed, and said, if you take registration in one country, all the 160 countries says, yes, we respect that registration, unlike the other industrial IP. What are the requisites? Again, copyright is very beautiful, simple, but yet it will earn for you. It should be original work, it should be fixed, and it's not tangible. So it should be tangible. Fixed as in, tomorrow I do a makeup on my face and I can't claim rights over the makeup because it can't be washed away. That is what it means when I say it should be fixed. Tangible meaning, in patent, ideas can be granted rights. But in copyright, you cannot go to copyright office and say, hey, in the next 5 years, I may write a book, I have an idea, protect that particular idea. No, your book should be complete. Only the completed book, you will have to file for the copyright registration. The best case study for the Microsoft is what I can give. There are a lot of copyright infringements, but as of now, I'll take Microsoft, because Microsoft has been, and I really appreciate Microsoft in having their core team doing this due diligence every now and then. They are very particular about granting licenses. They use the help of a software, and they see what are the software which the piracy, and they also monitor the counterfeiting of the Microsoft products, and this way they have filed various cases, and one such case is in the slideshow. Let us go to designs. Designs will not protect any utility pattern, as in it will not protect the unlike patent, it will designs will protect only the aesthetic sense of your product. It could be let us say a phone. Apple design is on the phone. The Apple phone is something which has its, like I said, the curving of the Apple phone was first designed way back, I think, in 1990s. So every time Apple comes out with pretty much the same structuring, they always file a design patent, a design application, and they get the grant for it. The designs are given for those inventions which are solely based on the judgment of your eyes. The aesthetic sense is only protected. It can be two-dimensional or it can be a three-dimensional. Two-dimensional in terms of the saree designing is also protected on the under the Designs Act. Three-dimensional, I can give the example of Coca-Cola bottle. These are all three-dimensional figures which can be granted design protection. Like I always say, prime requirement of any registration of IP is it should be novel. In designs, it should be novel. Point number 2 is it should be reproducible by the industrial means. It should not be something because in copyright, a sculpture can be given a copyright. But can a sculpture be produced in the industries? No. If it is something which can be reproduced in the industries, these come under the design registration. Also remember, for patent and design, Prabhavati ma'am also mentioned very specifically, please do not publish your ideas of design and patent. We call it as utility patent and design patents. Okay, do not publish it unless and until you file the application. The day you file the application, from next day on, go tell the world it is fine, no problem. But until then, please ensure on filing the protection, maybe a preliminary application, as in the provisional patent application you can file. For design, it doesn't cost you much. You can just file a design application. When you're going to the exhibitions, you will have to display something. Before that, kindly ensure that you file the application for registration, because that is one of the prerequisites. Anything which is public knowledge, anything which is already out in the public, like ma'am gave lots of examples of Thomas Alva Edison and all that, you cannot claim rights over it. If it is in the public, it is public knowledge and they do not go beyond that. This is Dabur. This is a very old case and it is a nice case because Dabur has had this design registration for the bottle and the cap, and one of its competitor, and it was nice way back then. Yeah, of course, though I don't have much hair now, I used to use Amla, Dabur Amla, and the bottle was very nice to use as a child for me. I used to like it. And then there was some competitor who is VN Cosmetics, and they sold oil in pretty much a similar. If it was kept next to each other in the market, people would deceptively buy it. Dabur sued the company for infringement. Injunction was granted, and they had to stop selling those products in the market. Next important thing is trade secret. Like I said, you will ask me, madam, you just told me don't publish it. There is some urgency. I have a lot of investors coming in. I want to pitch my product. Yes, please do it. Always ensure that you have confidentiality agreements, strong confidentiality agreement, and not a single page, two paragraph agreement wherein they both sign and say, okay, I will not tell you anything in the whatever is being disclosed here. No, please have strong confidentiality agreements in place. Maintain your trade secrets. One of the important tool all the corporates follow, or 99% of the corporates who are into technology field, even to this day, follow the concept of trade secret, because not everything in the world can be patentable, or it is not something which should enter the public domain. So there are companies who include trade secret into their strong IP portfolios. It means not disclosing your prime core of competitive advantage of a business. It has to be kept as a secret among a few individuals. How do you do that? You might be 2-3 people. This is where this is primarily, there is no law framed for it. It is primarily governed by your agreements, which I just told you. It should be very strong agreement. Best example is, I'm sure it's lunchtime. No, not yet. Okay, best example I can give is of the KFC. KFC, all of us know they have their 11 herbs and spices, which is kept as a trade secret since 1940. It is a huge task. Believe me, it is not easy to protect something as a secret for that long. But yes, they have been very successful. And many in the culinary industries, there are a lot of companies who are into momos or donuts. All of these people come out with different recipes, since patent or any IP law as of today is not protecting the recipes as such, and which they don't want to disclose also. They have already been ensuring that it is kept as a trade secret. And there are a few other technology companies, their prime algorithms is, it can't be patented. So what they do, they keep it as a trade secret. Okay. So for you people to take back home as a startup, always remember, if you focus on your intellectual property rights the right way, if you strategize what is yours, what belongs to you, and how to use it, you will in no time, with a little bit of advertising and little bit of help, hand holding from BTPC or your incubation centers, you can be a very successful a startup as such. Because even sitting now, there might be a lot of startups which have been in discussions with the promoters, and there are companies. In fact, when I was just going through some article 3 days back, as of December, 215 startups were acquired by major companies from $200 million, from fintech to small agri care. 15 people. I met one guy in Thai, and this guy has got an idea. He was a speaker. He is into selling raw materials to railway industries. Okay, which it is a very niche industry, and he has got around 40 people with him, and his turnover is 4,000 crores. That is what he said. 60 people, 4,000 crores. And what does he do? He's got a software. What does that do? It will bridge the link of, especially during the COVID period, because there were a lot of disruption in the construction field. What he did was he bridged the gap between the railway industries, or basically a construction industry, and the area where, and the source could be cement, could be metal. That's the only thing he does. He sits with 60 people, he coordinates, and yes, it is done. So this is how he's earning. So you being a startup, always ensure, get the professional help. Please understand, you don't have to be scared the moment you have an idea. I've seen a lot of people either being absolutely careless or they're overprotected. Both does not help. Go talk to somebody. Go talk to a professional. Understand what is your IP. Understand if that particular anything, any idea doesn't mean you being a startup. First have to understand what is your core. Core could be you will get 15 ideas, not like all the 15 ideas tomorrow you're going to patent. 15 ideas, of that 14 you keep it as a trade secret. The 15th one adopt, where you're choosing for this particular problem, as of this day, this is a solution. If I enter with this solution, I have a leverage. Take the leverage. For that leverage, take the professional help, understand what all IP rights can be used to insulate your idea and where you can protect it. So that is where know your IP. If you can't understand what your IP is, you can definitely not protect it. Tomorrow you will be sitting and saying, I wish I had protected, because a close friend of mine who I know for the past 15 years, he neglected. He is an entrepreneur, and he's a consultant. He had a fantastic idea in the health sector. Apparently, I don't know what got on to him. He came up with an idea and regarding the cancer and how to treat a cancer patient. He took this idea for the best of the society. He took it to one of the leading cancer hospitals, and I do not want to name that hospital. Trust me, this guy, for an appointment with the owner or that lady of that hospital, he took around 1.5 months. He got an appointment. He did not trouble himself to at least file a non-disclosure agreement, confidentiality agreement. He did not do anything because he was focusing more on the better good of the society. He went there, he sat, he said, he spoke completely for a good 3 hours, had a nice cup of coffee, and at the last it seemed she said, I am not very happy with it. Let me think and get back to you. By the time she got back, that product was already in the market, the patent has been filed, and he's sitting and scratching himself. I only wish that I had protected it just by filing at least the provisional specification. And that he tells to me, which is very ironic. Okay, so please, like I said earlier, there is never too early in intellectual property, but what applies is how late you are. If you're late, you cannot undo what has been already copied. And think why you need IP. Okay. If you would say, like my friend, who wants to, why to protect IP? Let's do good. Let us keep it open. Let everybody copy. No, that does not happen. If you don't protect your IP, innovation, we have learned it over and over again. If your IP is not protected, innovation is less. How, you ask? For innovation, you always need a lot of money. Nobody, just except for the 3 Fs which I said, the family, friend, and the fools, nobody will give you money to innovate more unless and until they find the returns of money in themselves. It finally breaks you down to that boiling point of money. So protect your trademarks. Please be realistic. Please understand what is your core idea. Don't go ahead and run and protect everything under the sun. No, understand what is needed, what is your core business, and which area are you, which market are you targeting? Is it China, India, US, UK? Which is your core business market, and target that and be realistic in protecting your ideas. Of course, until you're filed a patent, until a design has been filed, please keep your ideas a secret. Yeah. Thank you so much.
Thank you, ma'am. Many thanks for your time, ma'am.
Participants, if you have any queries, you can please unmute yourself and you can ask ma'am.
There seems to be a raise of hand. There was a raise of hand, I think. Somebody can speak up. Any queries from the faculty?
Many thanks for your time, ma'am. I want to thank and express my gratitude to to our Chairman Sri SNV L. Narsimharaju, Principal Dr. N. Kannan, HOD faculties, and students of the Oxford College of Engineering. Our extreme gratitude to Srimati Prabhavati Rao and Srimati Soumyashri. Thank you, ma'am.
Thank you, everyone.
Thank you, everyone. It was our pleasure. Thank you, Soumya, for taking us through the excellent presentation and the food for thought provided to the startups. Thanks so much.
Thank you, ma'am. Thanks a lot.
Thank you, ma'am. So with the kind consent of our convener, we are signing off this session. Thank you.